Hello, my name's Catherine Mitchell and I'd like to welcome you to the Mitchell Law Tea Break. This is our occasional series of videos for HR professionals where we like to have a chat about various aspects of employment law. I'm here today with our in-house barrister Joanne Sefton and the title of this tea break is Dismissals Outside the Box.
It sounds a bit like soap character Let's Hit This Outside type fighting talk.
Are you referring to the fact that I'm a Mitchell?
Of course you are.
No, we're talking about dismissals that don't fall comfortably within the three main reasons, so conduct, redundancy and capability or qualifications, which are usually bracketed together as one category, although it's almost inevitably capability rather than qualifications that leads to dismissal.
Of course, and on top of those straightforward reasons, you've got two others in the statutes. When a statutory duty or restriction prevents the employer from being employed, and some other substantial reason or SOSR, the mop-up clause.
That's right, and you've got some other slightly off cases where you can argue that a dismissal isn't a dismissal at all, so cases where the contract is frustrated. These alternative possible reasons for dismissal might not be in the mind of a management team or HR department if they have a difficult situation, but sometimes they provide an answer, so it's worth having a think about it.
Okay, our main focus is going to be on SOSR, so let's start there. Obviously there are unlimited examples of SOSR dismissals, that's kind of the whole point.
Yeah, and I tend to see them as falling into two camps. Firstly, a situation which might fall into one of the other fair categories, but the employer isn't confident that they're going to meet the test. And the other category I'd describe as for other more random reasons.
Okay, so thinking about the first category, the obvious example is business reorganisation. It might not technically be a redundancy, but that dismissal could still be fair under SOSR.
Well, exactly. The SOSR gives businesses more flexibility when they have good reasons to dismiss, but they can't say that the requirement for that work is diminishing. And the other interesting group of cases is the personality clash type of case. They might be better described as conduct cases, but because it's often hard to pin it down to misconduct, it's more attractive to go down the SOSR route.
Yeah, I've experienced some cases where the personality clash has worked well. I think it's important that it's a clash that impacts on colleagues, and ideally more than one. Tribunals can be sceptical if you're arguing that there's a clash between the employee and their manager.
Yeah, and one thing I get quite regularly is employers looking to dismiss a disruptive, difficult to manage employee and say, can we label it as breach of trust and confidence? I think that's another version of your personality clash with the management or the business itself, and it might be theoretically possible to defend a claim on that basis, but our experience shows that it doesn't go down well with tribunals.
Yeah, I think often it's a failure to properly performance manage an employee and to keep records of the performance management process that's behind that kind of scenario. It gets to the point where the employer is desperate to dismiss now, but the reality is that they've brought the situation on themselves by not putting effective performance management in place in the first place.
Well, that's right, and of course there may be a variety of reasons for that, but you do get to the point where it's difficult to dismiss quickly unless you're prepared to put a generous settlement on the table. And some employers are comfortable with that, but others less so. The time's marching on, so let's throw some more random SOSR dismissals that you've come across.
I always like the married couple ones. I've had quite a few where someone's dismissed not because of something they've done, but because of something a spouse or partner's done. And there can be a discrimination angle to that, so that's interesting to get your head round.
And then there was recently a fascinating case that went all the way to the Supreme Court, the Riley and Sandwell Council case. It was about a head teacher who had a close friendship, although not a romantic relationship, with a man who was convicted of possessing indecent images of children. And she didn't disclose the relationship or the conviction to the school and was ultimately dismissed for gross misconduct.
Well, I suppose if she'd come clean, they wanted to dismiss, they'd have been in SOSR territory, but sometimes non-disclosure can move it into misconduct, and that can make it a cleaner option.
Yeah, and there was a fascinating judgment from Lady Hale saying that there could be an argument as to whether conduct which wasn't in breach of contract could ever amount to gross misconduct, and also whether it was time for a reconsideration of the long-standing Birchall test, but neither of those points were taken.
Very interesting. We're fans of Lady Hale here, aren't we?
We are. She's the first woman president of the Supreme Court, all-round legal genius, and we've even got the t-shirts.
Brownie points for you. Other types of SOSR then. I've had cases where the employees received a prison sentence, and that can also be frustration of the contract.
And I've had reputational damage cases where the employer finds out that an employee has done something which isn't misconduct as such, but is incompatible with the ethos of the organisation.
I suppose one of the more common and slightly more mundane scenarios is where employees won't sign up to new contractual terms. The advantage there is that there's quite a well-established process to follow in terms of what you have to do for consultation and so on. if you take care as an employer and you get the right advice, you can probably be fairly certain of doing that lawfully.
Yeah, and it's a point worth making, isn't it, that the procedural requirements are less clear around SOSR dismissals than around other types of dismissals, and occasionally that can be an advantage if you come into a situation where the procedure hasn't been up to scratch for whatever reason. If it can be presented as an SOSR, they're a clever way to avoid an ACAS uplift.
There can be, probably not the best idea to take that tactic from the start.
No, and I fear we're running out of time, so it's been a bit of a whistle-stop tour, but interesting nonetheless.
Yeah. Before we go, we should say if you like Catherine's Lady Hale t-shirts, they're sold in support of the Billable Hour campaign, raising funds for refugees. If you Google Billable Hour charity, you can find out about it and even get your own if you like.
Thank you for watching the Mitchell Law Tea Break with a fashion slot this time, and see you again.